Never before seen evidence in Special Prosecutor Jack Smith's election case against former President Donald Trump. This is a 165-page filing, so it is a lot to go through, and our team is going through it as we speak. I want to bring in CNN's Paula Reed and Caitlin Polantz here with us. Paula, tell us about this filing.
So we are just 1 month right now, of course, from the election, and a federal court here in Washington has just released what is expected to be the most comprehensive look so far into the 2020 election interference case against former President Trump. As you said, our team right now is going through this, but some of the things that we're looking for are potentially never before seen evidence. Like, for example, what former Vice President Mike Pence or former White House Chief of Staff Mark Meadows told investigators. But this is really unusual. Of course, though, this is an extraordinary case. Back in July, the Supreme Court ruled that former President Trump does have some immunity from prosecution and tasked the judge overseeing this case, Judge Tanya Chutkan, with trying to decide which parts of this case survive that decision. So the special counsel, Jack Smith, he recently submitted a roughly 200-page filing laying out what he believes his case looks like after that Supreme Court decision. Because remember, the Supreme Court decision was not only about the types of charges you can bring against a former president, but also the kinds of evidence that you can use. So right now, they are making what kind of looks like an opening statement that you would make in trial to the court, trying to convince them that a large portion of this case should survive even after the Supreme Court's ruling. Now, former President Trump's lawyers have opposed releasing much of this, but right now we are going through to see what new evidence or new details from this case are going to be revealed in this highly unusual and historic filing.
Caitlin Polantz, over to you. What are you seeing in this filing? Obviously, a lot of information to get through, but what are your initial takeaways?
Yeah, one of the things here that you're seeing is the Justice Department not laying out their full case against Donald Trump in this filing, but they also have to be very specific about the things that the Supreme Court says we're not sure if there's immunity. The court has to figure this out. One of those things is the interactions that Donald Trump had with Mike Pence, who was his vice president. So in one way, there could be immunity, but in another way, Mike Pence was the president of the Senate on January 6th. And so the Justice Department is digging into interactions that Trump had with Pence or around Pence. And I haven't been able to read that much of the filing yet. We really just got it just a couple minutes ago. But one of the things that I'm seeing is discussions about how Donald Trump and others, conspirators, co-conspirators with him, were trying to pressure Mike Pence. So there's discussion of Donald Trump sitting in the dining room in the White House, sending a tweet about Mike Pence. Also having a private attorney, that is very likely John Eastman, an attorney that worked with Trump after the election as a private advisor, pressuring Pence. And all of that, the way the Justice Department is doing this to back it up is they're using people's grand jury testimony, as well as interviews people gave to the FBI, and also search warrants, things that they did, like search Donald Trump's Twitter account. And so when you put this all together, you get evidence we have never actually seen before. Mike Pence did testify to the grand jury, but Boris and Brianna, we have no idea what he said in there because he's never testified publicly about this before.
Yeah, very interesting. Paula, so what is ahead here?
So I think what you're going to see is this is going to go from the court of law to the court of public opinion. And I would expect that the former president, as his attorneys have, he will try to argue that releasing this is some form of election interference. Again, this case is not expected to go to trial anytime soon. If former President Trump is reelected, this case is expected to be dismissed by his attorney general. So the idea of releasing a long narrative like this from prosecutors, highly unusual. And his lawyers have argued, as they really have in all of his criminal cases, that any effort to release additional evidence is an effort to interfere with the election. Now, look, there's no precedence for this. I mean, this is just such an extraordinary circumstance. But I think that's what you're going to see next. The former president is going to argue that allowing even a redacted version of this filing to be released to the public is going to potentially hurt him in the election, and that this is part of this larger conspiracy that he alleges by judges, by prosecutors, to hurt his chances in November. So I would expect that after initially we look and find the new new details. I think that this is absolutely going to be used again in the court of public opinion to once again try to frame the former president as a martyr or a victim of the justice system.
CNN's Evan Perez is also with us. Evan, obviously, this is notable given the longstanding DOJ policy around prosecutions on figures that on candidates close to election time. But this isn't exactly a new prosecution, right?
Right, exactly. And by the way, we're coming up just a few more days before essentially the Justice Department is supposed to go quiet. They have a 30-day unwritten rule, a 30-day quiet period that begins effectively on Saturday, right? Because you're about a month away from the presidential election. And so the Justice Department really would not be able to release any of this, in the next 30 days. However, this is something that a Judge Tanya Chutkan, has decided is appropriate for the public to see. And there's still, obviously, there's a lot of information. You can look at some of the pages in here that are redacted. There's details in here that are going to be, that will not be public. But one of the things that is notable in here already, just from reading just the first few pages of this, this document, is you can see the emphasis that the prosecutors have made on the idea that what Donald Trump is accused of here in this case has to do with private conduct, that it is not what he did as the then sitting president of the United States, that what he was doing was in his private capacity, in his personal capacity, trying to essentially steal the election that he had lost. And so that's one of the things that you see already in some of the language that is written in this filing that the court has now released. Again, just a few days before the Justice Department's 30-day quiet period goes into effect, guys.
Paula?
So right now we're reading through this, and as you can see, we're reading around redactions. Certain names are blacked out, so we'll have to put those pieces together. But here you see prosecutors painting a picture of someone who's trying to subvert the result of the election even before it happens. On page 5 of this, they talk about how the then president was talking to his campaign advisors about how the election may not be final. The results may not be final on election day. Concerns about mail-in ballots that they believed would benefit Biden, and that they decided, quote, that in such a scenario, Trump would simply have to declare victory before all the ballots were counted and any winner was projected. So this is just one of the details in this, something that we have heard before, certainly, but these are the kinds of details. This is how the special counsel is telling its story, explaining sort of its narrative of the case against former President Trump after the Supreme Court ruled that he does have some immunity. Now, I want to note, again, if Trump is reelected, this case is going to be dismissed by his attorney general. But if he is not, this case is expected to very likely go back before the Supreme Court, because the reason this was filed is because Judge Tanya Chutkan has been tasked by the justices with assessing the charges in this case and the evidence in this case against their decision in July, granting him some immunity and deciding what remains. And I'm sure no matter what she says, one side is not going to be happy and they're going to appeal. And both lawyers on both sides of this case have told me they do expect this to go back to the Supreme Court. There was sort of an implicit invitation that the justices extended. They said, look, here's our decision on immunity. Let's go back and reassess the January 6th case and then maybe come back up if there are any additional questions. So if this case goes to trial, it's still going to be a long road. And this is definitely the last opportunity that voters have to see what prosecutors gathered in this multi-year investigation. Because, of course, again, this case is not going to trial anytime soon.
And Caitlin, you've been reading through this 160, 180 page filing, and you found a specific detail about an attorney. What did you find?
Yeah, this is not an attorney, someone described as an assistant to the president. So somebody who was working in the White House from August 2020 on, and that the Justice Department says to the court, this person is important in this case because even though they were working in the White House, they were there to serve as a conduit of information from the campaign to Donald Trump, the defendant. This person is not named. It is person 9 in this, but this is the sort of person person who would be a very key grand jury witness and then who would very likely be a key witness at trial if Donald Trump were to go to trial as a defendant. Some of the details that they're laying out here that they believe, the prosecutors believe, Judge Chutkan needs to know as she decides whether there is immunity around Donald Trump. And they're trying to convince her there isn't, because what Donald Trump was doing was part of his campaign, his political effort, and not his official duties as president. One of the things they're saying is that this person was having conversations with Trump saying these fraud allegations about the election could never be proved in court and that it was BS what was happening here. And then at the same time, Trump was talking to that person about putting an outside attorney in charge of the legal effort to try and undermine the election, that person ultimately becoming Rudy Giuliani. But person 9 is one of those many, many witnesses in this investigation who are anonymized in this document, but who the Justice Department is telling the court, look into this. This is the evidence we have, and this is the type of witness we would have to go before a jury at a trial to say that Donald Trump was acting in an illegal way that should never have the protection of the presidency around it, that it was campaign activity, even though person 9 worked in the White House.